Hello, everyone. Welcome back to our Lunch and Learn session. A very warm welcome to all of you today. My name is Rosnita from 𝗟𝗨𝗡𝗟. Today, we have Miss Carol for topic the Employment Act 1955, and she'll be sharing about understanding the important changes in the Employment Act. Okay, if you have any question regarding this topic, do leave your message in the comment section, and Miss Carol will answer them right after her presentation. All right, let's not wait anymore. Now I pass this mic to Miss Carol.
Okay, good afternoon, everyone. Welcome back to our session on Lunch and Learn again. So hope you can have lunch and learn at the same time. That is why it's called Lunch and Learn. So our topic for today is on Employment Act 1955 and Amendment Act 2022. As you all may be aware that we have several changes, 14 to be exact, 14 major changes, which are going to be enforced from 1st January 2023. So here I am to highlight to you what are the 14 changes. In summary, as we only have about 1 hour to go, so there'll be a summary of all the changes at the end of the session. Feel free to ask any questions so that I can elaborate to you and then to see how we can help you further. All right. So today's session is going to be from 12 to 1. So brief information about me. I'm a HR practitioner for more than 20 years. I've worked in several organizations, local and multinational companies. In my capacity as HR, I have handled all general aspects of HR, including employee relations, industrial relations, and many others. All right. So for the past 5 years, I've been training various corporate participants on HR matters, including Employment Act. So this year, of course, it has been a busy year because there are many changes, and I've been conducting many webinars and also training programs to HR practitioners and those who are interested to know what are the changes. All right. So that's very brief information about me. Let's move on. What are we going to cover today? So today we'll have a short introduction. Then we'll go on to scope of the Act. Number 3, apprenticeship, calculation of wages, pregnancy and maternity, work hours, leaves, foreign employees, flexible work arrangement, dispute on wages, discrimination, sexual harassment, and forced labor. So these are all extracted out to be discussed today because the changes are pertaining to these topics. So let's go to the introduction. What is Employment Act 1955, or in short, we call it EA 1955? All right. It is an act which is very beneficial and one of the important acts or law for various stakeholders such as employees, HR, and also organization. For employees, of course, it protects the employees and keep the workplace fair and safe. It also provides guidelines for the employees. Okay, whenever an employer or an organization comes out with some rules and regulations, the employee can always refer back to EA to check whether it is fair to them. All right. Secondly, for HR function, this is one of the important acts to enforce discipline, to define what employer and employee are responsible for, and again, provide guidelines for HR itself. All right. So when you come up with rules and regulations or any policies, always HR can go back to EA to be used as a guideline. So it is very beneficial. Lastly, of course, and not least, for the organization as a whole, Employment Act 1955 and Amendment 2022 and the amendment which is going to come into force in 2023 is a must. Most of the aspects have to be followed, otherwise there will be heavy penalty and fines. All right, so it helps the company to enforce and enhance rules and regulations as well. So meaning not only the HR, even top management or individual department managers will find this helpful to keep their rules and regulations in the company. All right, so that's very briefly what is the importance of Employment Act for employee, HR, and also organization. So we need to know the importance before we go into the details. Otherwise, we go into details, we may say, oh, why should I follow this? Okay, so it is important for all these various aspects. All right, let's move on. So before we dive into the EA changes, we need to know what is the definition of employer and employee itself. Okay, so not everyone is considered employer and not everyone is considered employee according to the definition in the Employment Act. So you need to define that. So for employer can be an organization, government agency, institution, agency, company, professional services, firm, non-profit association, small and medium enterprise, store, or even individual who employs a person who is called an employee. As long as these organizations employ a person and call them employee, then they are termed as employer. Okay, so further down, we break down what is the employer. And this is found in section 101C in the Employment Act. Okay, so definition, employer, he controls or directs the manner of work of another person, controls or directs the hours of work. So meaning he will tell, okay, today you need to work 9 to 5, Mondays to Fridays, right? C, where he provides tools, materials, or equipment to another person to execute the work, right? So he provides stationaries, computers, handphones, or telephones so that an employee can do the work. D, where the work of another person constitutes an integral part of his business. So without the employee, the business won't run. So it is an important job scope that the person is holding, then they are called an employee, right? E, where another person performs work solely for his benefit, okay, for the benefit of the company. And F, whether or not payment is made by him in return for work done. So employee definition can be either the person is paid or not paid. That's what the F says, all right? Let's move on. So we've covered the employer definition. Now we dive into employee. What is an employee? Employee, according to EA, is an individual who works part-time or full-time under a contract of employment. It could be whether oral, written, express, or implied. Okay, and has recognized rights and duties. So what it means is it could be someone could be employed to work with a written appointment letter, or they could have been appointed without any written letter but verbally already, okay, or express or implied, meaning they have given the work, okay, you do the work 9 to 5, Mondays to Fridays. So it's already implied. Once they start working, they are an employee. So same thing, we won't go through details. A to F is the same as what the employer provides. Now the definition is switched to employee, right? So again, this can be found in section 101C. All right, moving on. So we do have categories of employees, as mentioned earlier. So they are full-time, part-time, temporary, contract, foreign, and apprentice as well. So full-time is 9 to 5. let's say the company works 9 to 5 Monday to Friday, they also work 9 to 5 Monday to Friday. If part-time, could be they only work Mondays to Wednesdays, 9 to 5. Thursday, Friday, they don't come to work. Or it could be they work from 9 to 1, Mondays to Fridays, half a day only, right? Could be any number of hours or days that they work. They can be called a part-time employee. Next is temporary. Temporary could be they are engaged to work only for 3 months or 6 months. Then they are considered temporary workers. So after that, they will leave the organization. Next, contract. Contract would be someone who's employed on a longer temporary basis. It is still considered temporary, but it's on a longer basis. Usually it's like 6 months, 1 year, or 2 years. They are given a contract because of some project that will end at the end of 2 years. So they are only required to work for 2 years. After 2 years, they don't have any work to do, right? And next, foreign. Foreign, of course, all non-Malaysians who come to work in our country are called foreign workers, right? Lastly, apprentice. Apprentice are the persons who we employ to work to learn some skills, some manual skills. Example, repairing computers or repairing cars. So they can be employed to work in an organization. Then they are considered as employee as well. But their title is apprentice because they are still learning on the job, right? So there are some exclusions for apprentice. Exclusions are section 10 to 16 of EA. These sections are talking about termination clause. So the termination clause does not apply to apprentice. And one of the clause on section 16 is on estate workers. So estate workers, of course, we exclude from this definition of apprentice. All right? Okay, let's move on. So what are the scope of the act? Okay, so if you see a red, yellow star here, so these are the changes I put in a star. So as we go on to the other slides, you will see the stars here, meaning that this is a change which will come into effect on the 1st of January 2023. All right, so this is the first one. First one, EA will now cover employees as per the amended first schedule of the EA. All right, so this is in the first schedule. Any person who has entered into a contract of service, okay, all clauses in this act applies to the above mentioned employee, except for the following. So if currently only employees who earn 2,000 and below are covered under the Employment Act, okay, 1st January onwards, 2023 onwards, all employees will be covered, regardless of their salary, except for this clause. Okay, so other clauses apart from this, all are covered, all employees. No matter how much you pay them, 20,000, 30,000 per month, they are covered under the Employment Act. That's what it means here, all right? So for those whose wages exceed 4,000, these are the exclusions. Subsection 60, 60A, 60C, D, and D, what are they? Let's look at to the next slide. These are the ones. So basically, it's talking about overtime, right? And the last one, 60J, is termination, layoff, and retirement benefits. So meaning the employees who work, who earn, go back here, more than 4,000 a month, meaning 4,001 ringgit and above, okay? You don't have to pay them overtime. And then you don't have to pay them the termination benefits in case you're terminating them. 60J will relate to layoff, mostly on layoff, retrenchment. Okay, so meaning you don't have to pay them overtime, don't have to pay them retrenchment benefits. So those who are earning 4,000 and below, you need to pay them overtime. So currently only 2,000 and below. So now the salary increased to 4,000 and below, you need to pay overtime. right? So take note of that. This is very important aspect of the Act coverage, and then you may need to revise all your rules and regulations and policies. And if you're using payroll software, by now you should have changed the calculation methods in the software itself for overtime, right? Moving on. The next change is on apprenticeship, all right? So currently, apprentice need to be employed for minimum of 24 months or 2 years, right? So moving on from next year under section 2.1, right? You can employ an apprentice for a minimum of 6 months and maximum can be 24 months. So meaning after 6 months, you can say, fine, that's it. Your apprenticeship with the company ends. Okay. So it could be 6 to 24 months. That's what this Act, the new amendment says. Next, moving on, number 3. This is actually new for the Act, okay, but it's not new for practice, okay. This has been practiced all along. It should be that way. It's the correct way, but it's not stated in the Act. So therefore, some companies were confused. Some HR or payroll personnel may be doing it wrongly. The calculation may be wrong. So they found out about this. That's why the authorities or the HR ministry introduced this calculation of wages formula into the Act itself, so that they can refer to this Act when doing this calculation. So this calculation is for an employee who is employed on a monthly rate of pay and has not completed a whole month of service, meaning he may join in the middle of November this month, okay? Maybe he didn't join on the 1st of November, he joined on the 10th of November, okay? Or he resigns without completing full month, meaning he joined maybe somewhere in 1st of January this year, but then he decided to leave on the 15th of November, right? Or it could be he took some leave of absence without pay or no pay leave for the month. He exhausted all his annual leave and then he decided to apply for no pay leave, right? Or he was called for national service, right? In case suddenly he's been called, he can't work anymore. So for this, all these scenarios, you need to calculate their prorated wages. So now the formula is given. You take the monthly wages, divide by number of days of the particular wage period. So let's say November, he didn't work full month. So you take his salary, divide by 30 days. November has 30 days, right? Then you times number of days eligible in the wage period, meaning number of days he has worked. So if he has worked for 15 days, then you take the wages, divide by 30 times 15. Okay, so if he leaves in December, maybe 10th of December, then monthly wages divide by 31 because December has 31 days, right? Then times 10. Okay, so that's what these changes means. Actually, it's no change as I mentioned, but they want to put in the calculation to avoid confusion, right? So this is in section 18A. Okay, let's move on. This is section 37, Fourth Amendment, pregnancy and maternity. So those who are going on maternity leave currently is 60 days. So from 1st January 2023, it will be increased to 98 days. So this is applicable from 1st January onwards only. So let's say currently, suddenly they want to go on maternity leave in November or December this year, they still follow 60 days. Okay, so it cannot be, 60 days they've taken today, this year, then the balance will be another 38 days because it crossed over to next year. No, it doesn't work that way. It works from when they take. Okay, this is what I got information from the ministry itself. Although it's not stated in the act here, I got the information from them. So this is what it means. So if they're going on maternity leave is starting from 1st January onwards, then only they're entitled for 98 days. So otherwise is this year is still 60 days. Okay. Other clauses remain the same. So I shall not go through the details of other clauses. All remains the same. Okay. So only thing it changed is 98 days. So okay, I've included all the other clauses. You may read them. So I'll just go slowly. You may read them, but it's all the same as per what is found in the Act. No changes. All right, so we shall move on to the another change is under section 60A, all right, meaning of work hours. So this is one very important amendment. Currently, employees are required to work, or the maximum working hours shall be 48 hours in a week. So this will be changed to 45 hours in a week next year, right? So the other clauses remain all the same. I've included here. They need to work for 8 hours a day, excluding a period of rest. They can work up to 5 consecutive hours, and then after that, they need to be given a rest time for at least 30 minutes. And then spread over, if let's say they're spread over the work, including all the rest times, it should not be more than 10 hours in a day. All right. Upon mutual agreement, see the last clause there. Upon mutual agreement, hours of work can exceed 9 hours a day, but it cannot exceed 45 hours in a week. So all this combination you can play around. Okay, how many hours you want to put. At the end of the day or at the end of the week, it should not exceed 45 hours. Okay, that's what it says here. Let's move on. The next change is on leaves. This is for male employees, all right, who is going to have a child. So they are given 7 continuous days of paternity leave. And they have to fulfill these requirements. Look at the 4 requirements here under section 60FA, right? First, they need to be married, restricted to 5 confinements, meaning they need to have 5 children to enjoy the 7 days. The 6th child onwards, they can't claim for these 7 days. That's what it means here. So 5 must be natural born children. Okay, that is also defined under maternity leave. It's the same. No foster children, no stepchildren, no adopted children, nothing. Must be natural born children. And another clause, third one, must be employed for 12 months prior to taking such leave. Right? So let's say he's going on maternity leave on the 2nd of January 2023. So he must have been employed since January 2022, at least 12 months. If he's below 12 months, then he don't enjoy the leave. He can take his own annual leave. Right? Next, last one. Employee need to notify due date at least 30 days in advance. So he need to inform the superior or HR usually to tell them, okay, my wife is going to deliver on the 2nd of January. So he must inform by 1st of December, 30 days in advance at least, right? So here you see all these clauses must fulfill. Next, let's go to the next one. This change is under section 60F. Another change on leave. This is applicable to everyone. Okay, earlier was paternity leave only for male married person who's going to have a baby. So this leave is for everyone. The numbers remain the same except for one change. Okay, leaves 14 days if employed for less than 2 years. This is on sick leave. Okay, we're talking about sick leave or medical leave, right? 18 days if employed for equals to 2 or more than until less than 5 years, 2 to 5 years, all right? 22 days if employed for equals to 5 or more years. And then you look at B below, 60 days of hospitalization leave, excluding sick leave. This is the new clause, right? So what it means is previously, let's say they've taken 14 days of medical leave in 1 year, then they are hospitalized, if the employee is hospitalized. So the 60 days is there, they have to minus 60 minus 14, then you get 46 days. So the hospitalization leave will be 46 days only because they have taken the 14 days medical leave. That is the current rules, okay? So moving forward next year, even if they taken 14, 18, 22 days, they will still have the 60 days hospitalization leave. That's what it means here, right? So this is full. You don't minus from the medical leave, okay, excluding sick leave. So take note of this. Next change. Next one is hiring of foreign workers, section 60K. No employer shall employ a foreign employee unless prior approval has been obtained from the Director General of Labour. So they need to put in their application on foreign worker employment. Once approved, then only they can proceed to employ, right? It's very straightforward. All the other rules and regulations, you need to go deeply to see how the application process. So today I'm not covering that, right? Next, termination of foreign employees. So this one is also the employer shall, within 30 days of termination of service, inform the DG or Director General of the termination if they fulfill all these 3 clauses. The employee is terminated, the employment pass has expired. Employment pass is the one they get to when they come into Malaysia to work, right? It's a permit to work. The employee is repatriated or deported, or the C means if the organization want to send them back to their home country, all right? So if all these things happen, 30 days before all this happen, DG need to be notified, all right? The last clause, if the employee resigns or absconds, most of the time, sometimes they run away, abscond, okay? They don't turn up for work. Then the employee shall inform the DG within 14 days of all this happening, all right? This is when the organization is taking action. You have 30 days before taking action. The last clause is the employee themselves resign or abscond. Then you have 14 days to inform, right? Let's move on to the next one. Okay, so this is an interesting one, new one, clause included under the sections 60, F and Q, right? Flexible working arrangement, or short form, they call it FWA. Of course, you know this one, if you are aware, this arrangement, some companies have been practicing before it came under the Act, okay? So they wouldn't have any problems implementing this. But for some companies, it may be new, or some companies would have been practicing since the COVID-19 pandemic, okay? Because some of us were not allowed to go to the office to work. So some employees were working from home or working from another place. it could be co-working place. All right. So because of that, the situation of the pandemic and talking about work-life balance for employees as well, this clause in the act is introduced. So it must be enforced from 1st January 2023. So what does it mean? Flexible working arrangement. You can vary the hours of work, days of work, and place of work for the employee. Employee should be given the opportunity to write to employer to request for flexible work arrangement. Okay, so employer may approve, refuse the application within 60 days in writing, indicating grounds for refusal. All right, so I've put here in this box here some of it only. There can be more. These are types of flexible working arrangement that you can give option for the employee to choose from, right? So one of it is, you see WFH is work from home. So example, they can write in to say that I want to work from home from every day, Mondays to Fridays, okay, 9 to 5. So I don't want to come to the office anymore, right? Example, if they write in, the employer has up to 60 days to reply to that. 60 days, not 2 months. You need to count the days. So the reply has to be in writing because we want to record everything in black and white. And then if you approve, fine, no problem. But if you refuse, some employer may refuse for certain reasons. If the employer refuses the request, then you need to put why you why you refuse. This is what it means by indicating grounds for refusal. Why are you refusing? Give reasons. All right. If no reason is given, then the employee may say, oh, it's no reason, simply don't want me to work from home. I still want to work from home. They have every right to do it. All right. Okay. So this is on the next change on FWA. Let's move on to the next one. Section 69. This is talking about dispute on wages. So penalties, fines does not exceed 50,000. Any dispute on wages calculation, for example, OT is not calculated correctly, prorated salary is not calculated correctly, there's a shortage, whatever, there's dispute. Previously or currently, the fine is up to 10,000 only, but now it has been increased. From next year, it will be up to 50,000. Fine for the employer, right? So example, second clause, look at the second clause. Let's say OT calculation was made incorrectly for June. Okay, the calculation method was wrong. Then the employer refused to correct it. Then the employee goes and files a complaint at the labor department. Then the penalty will be issued to the employer. Then that was for June. Employer paid the fine. So moving on July, still do the same thing. Still do the wrong calculation and pay wrong amount. So that's where the second clause comes in. If the offense is continued, then the fine does not exceed 1,000 each day. So for each day of fine, they will put in a fine. Each day of offense, they will put in a fine of up to 1,000 each day. Okay, currently it's 100 ringgit. So they have increased to 1,000. Okay, so these are the changes in the amount here. That's what changed in section 69. Right? Let's move on to the next one. This clause, okay, talks about discrimination in employment. The DG or Director General again may inquire into and decide any dispute between an employee and his employer in respect of any matter relating to discrimination in employment. Okay, so this one is after they've been employed. Is that if there's any discrimination, the employer can be fined same amount, up to 50,000. And if the offense is continued, daily will be up to 1,000. So discrimination can be any form: gender discrimination, race, religion, or even if they are discriminated because they are OKU, handicapped. So any form of discrimination should not be allowed in an organization. So you need to go back to all your policies, even like example, pregnant employees, you should not discriminate them. Say that, they won't do work properly, they are always going on leave, then you discriminate them in whatever way should not be done. All right, then this clause will come into play. Section 69F. So need to be very careful with this. Okay, moving on. Next one, section 81F and 81H. We talk about sexual harassment. An employer shall at all times exhibit conspicuously at the place of employment a notice to raise awareness on sexual harassment. So here I've extracted one from the ministry. Okay, this is like a poster just to show you an example of what you can exhibit at your workplace. So this could be one of it, or you could do your own one. All right, but they say conspicuously means must be accessible and visible to majority of employees. Cannot be inside a policy, or it cannot be inside. It can be, but you must put something else to be conspicuous as well. Like, for example, at the notice board, or even at the website, or intranet, internal website. So it must be accessible, conspicuous for all employees. And the fine, again, up to 50,000 again. An employer who does not act on the complaints is liable to be fined. So you must have a complaints mechanism in place for this, right? Complaints can come in only if the employee knows what to complain about, right? If not, they will not, some may not be sure what is harassment, what is sexual harassment. They may think it's normal, all right? That is why it's good to have this poster. Then when they come and complain also, they can indicate what actually happened, which one happened, all right? Then the complaint need to be looked into. So the HR process must come into play. You will say you need to give a show cause letter, you need to do some investigation and maybe go into domestic inquiry. All those need to be shown. If the matter goes up to the Labor Department or even Industrial Relations Department, then all your documentation need to be ready. Otherwise, be prepared to pay this fine of 50,000 ringgit. Okay, so that's what it means here. All right, moving on. So last one, we've come to the last amendment, forced labor. Okay, any employer who threatens, deceives, or forces an employee to do any activity, service, or work and prevents that employee from proceeding beyond the place or area where such activity, service, or work is done commits an offense. So again, this one can be fined up to 100,000 ringgit or imprisonment of 2 years or both. Could be fine and prison. Section 90B. So what it means is you can't force an employee to do some activity which is against the rules and regulations or against this act. Example, overtime. Overtime cannot be forced. So some organization, they may say, oh, you come in to work here, every day overtime must work for 4 hours. So they'll be working 4 hours, 4 hours, 4 hours for the next few months, right? So that is one form of forced labor. Meaning if they want to go back after 2 hours, they say, I'm tired, I cannot work 4 hours, they are not allowed to go back. If they go back, then they are punished in some way, right? So this is one part of forced labor. Or it could be you make them work 7 days a week. Okay, everyone else works 5.5 days, but some group of employees, you say, oh, you must work 7 days. Okay, that would be tantamount to forced labor. Okay, this usually happens among foreign employees. That is why this clause is included to protect these employees from what they call forced labor. All right. Okay, so that's the last part of the changes in very brief shared to you. So once you get that information, this is just for your thought process. Okay, what you need to do next, right? What new knowledge will you take with you? So now you have all the new knowledge that you have. Okay, you need to think of how you're going to use it. If you are HR or even an employee of an organization or a department manager or the owner of a company, there's lots to do, right? And then you also need to think the third step, what resources or support do you need? Okay, because I've given very brief information, so you need further resources or support. You may need that in order to implement all these changes effectively, right? And lastly, what are you leaving behind? So whatever that you've done, which is not aligned to this act, you need to leave behind. Or maybe some is not applicable anymore in your policies. Okay, come 1st January 2023, it won't be applicable, so you need to remove all of that and then replace with the new clauses, right? So you need to go through this process and think of what need to be done, right? So briefly, what can be done, I have here, very briefly. Okay, what next can you do? Knowing that all these changes are coming into force. First, determine and separate employees who fall within the scope, change job grade if required. So remember the overtime I mentioned, those who are 4,000 and below now can claim overtime. So how are you going to identify them? For ease of calculation purpose or in the software, you need to identify these are the persons who can claim. So you can separate them, maybe change job grade. Example, maybe now their grade is those who are under grade D, D1 to D4, clerk to example supervisor level can claim overtime. So those who are executive, maybe they are earning 3,008, but they are considered grade C. So now maybe you need to change their grades. Example, okay, within your organization, you need to evaluate, analyze, and do this so that your HR can have clear distinction who can claim overtime, who cannot claim overtime, right? 2, review and amend all employment contracts, rules, regulations, policies, and employee handbooks. Okay, if possible, employment contract you can review. Otherwise, you just renew the rules, regulation, policies, and employee handbooks, right? According to what all the changes that I mentioned earlier, right? 3, introduce new forms to be submitted for approval and for record keeping. So now, like paternity leave, they need to apply 7 days, and then there are some clauses there, right? So you may need to come up with a new form, leave application form for paternity leave. Then you can tick there, okay, oh, he's married, he has informed 30 days in advance. Other leave forms may not have this. So you may need to come up with another form. So this is only one part of it I'm mentioning. I'm just giving sample. So there are a few others that you may need to introduce new forms, right? And lastly, you need to brief the employees. Okay, all these changes, they may be aware some of it, they may not be aware of some of it. So they need to be briefed as well. Otherwise, they may not know what they are entitled for, or maybe they think, oh, they are entitled for more than what is stated in the act. They may not understand some of the clauses. Okay, so your duty, since you attended this webinar, or maybe you will attend some training sessions on Employment Act 1955 and its new amendments, then you need to brief your employees before 1st January 2023. All right. So these are, again, briefly what you need to do next. Okay. There are many others you need to do, but these are the major points I've extracted to share with all of you. All right. With that, I conclude our webinar for today. Hope you gain valuable information. And now I open the floor for any questions that you may have. We still have a few more minutes. I can answer some of your questions.
Okay, if you have any question regarding this topic, do leave your message now in the comment section and Miss Carol can answer them. Okay, looks like we do not have any question for today's session. Thank you so much, Miss Carol, for the great sharing, and thank you everyone for joining our Lunch and Learn session today. And for those who want to know more about what are the important changes, there's a question coming. Sorry, there's no.
Okay, I see a question there on apprentice. So what explanation do you need? Apprentice, you can employ them for a minimum period of 6 months. That's the change. Previously, you must employ them for at least 2 years or 24 months. You cannot employ less than that. So now it's going to be changed to minimum of 6 months you can employ them. So any other questions you have regarding apprentice?
Lina Awang?
Okay, there's another question.
Yes.
So here is included foreign employee. Okay, foreign employee is different from expatriate. Okay, expatriate are professionals who come in. Usually their category of salary should be 5,000 and above, and they are under professional category. They are not included under this act. They are not considered employee, right? So here is only foreign employees. So when you apply the employment pass for them to come in, it would be stated employment pass, or another one is expatriate. Okay, so if they are expatriate, all these Employment Act are not covered. Whatever clause here not covered, they will follow whatever contract is given to them.
Okay, we have another question from previous candidates.
Okay.
Yeah.
Is it about the apprentice to pay allowance? Okay. There's no indication how much allowance to pay to them. The Employment Act doesn't indicate.
Okay. I guess we close for the Q&A session now. All right. As mentioned earlier, for those who want to know more about the important changes, what are the changes for the Employment Act 1955, Miss Carol will be having workshop for the same topic on coming 6 and 7 December, as shown on the screen right now. Yeah, you can get the information. Okay, This will be held at Hotel Armada on the 6th and 7th. Okay, so please email or contact us for registration if you are interested to join. Also, don't forget to follow our social media platform for more information. All right, with that, we end our session. Selamat mengundi. Take care, everyone, and thank you.
Thank you and happy voting.
Bye-bye. Bye, everyone.